This is Dennis Kennelly. You're on the legal line with me. You'll also be hearing from our guest, my good friend Mark Sullivan, and we'll be answering all of your labor-related and other legal questions to the extent that we can. And if we don't know the answer, we'll probably be able to tell you where to go to find it. So, just generally speaking, looking at the national scene, the Obamacare repeal bill was pulled off the table by Speaker Ryan because he didn't have the votes. So I think personally that the timing of the replacement for Obamacare, if indeed there ever is one, is somewhere far down the road. They're trying to come up with a compromise bill, but haven't managed to do anything with it yet. And we have no details. I think just generally speaking, everybody is going to look at any new bill in a very, very simplistic fashion. How does it impact me? Is it going to cost me more money? Is it going to cost me coverage? And I think these are very, very important things that the representatives and senators will have to take into account when they come up with a new bill, because you've got, depending on who you listen to, as many as 24 million people who now have coverage that may not have in the future. So that is a hot issue. As I said, my guest is Mark Sullivan. I've known Mark since 1973. We've probably tried more cases against each other than any other lawyer from our days back in the Navy. But Mark, you've got some really interesting research that you've done on the California Labor Code, which is, I think, a minefield for California employers. California workers have more rights than anybody else, many of which the employers don't even know about. And that could be problematic and expensive. So, Mark, why don't you tell us about heretofore unknown addition to the California Labor Code regarding immigration status?
Well, I don't know if I would say call it unknown. And Dennis, thank you for that kind introduction. I don't know if I'd call it unknown, but what prompted me to look at this is there's a brand new bill introduced in the California legislature. You know, we just had this huge battle on Obamacare. Now the next battle is, or ongoing battle, is the battle on immigration reform. And the California legislature is really aggressively staking out a position of essentially kind of all-out war with the Trump administration. This latest bill, this is not law yet, this is, but it's almost certain to pass in the California legislature, is called AB, that is Assembly Bill 450. And what this is going to do, basically, is it makes every employer in the state essentially a protector of undocumented employees in his or her workforce against ICE. That if the employer has noticed that that ICE is coming, the employer has duties to notify all the employees, and the employer has to bar the door and insist on a warrant. It's really extraordinary. I mean, it's really extraordinary because it's essentially forcing employers, regardless of size, to take a not only a vocal position, but an actual physical position in the debate on immigration. I think it's going to pass, and then it's going to be very interesting, when the federal courts get into it, as to whether or not an employer, as a citizen of the United States, has a duty to the United States government or a duty to the state government, and can be in violation of both. It's quite a fascinating piece of law. However, looking at that, brought to mind a statute passed in 2014 that you never hear about, and I suspect from the employers I talk to that most don't even know has been passed into law. Specifically, Labor Code 1019. Labor Code 1019 sets up what's called unfair immigration-related practices. And basically what it does It says that if an employer uses or even threatens to use E-Verify, which is the federal system of verifying compliance, that someone's lawfully in the United States, that the employer is then committing an unfair immigration practice per California law. What's shocking about the law that a lot of people don't realize is that if you violate the law, you, the person violating the law, lose your right to engage in any business in California. 14 days for the first violation, 30 for the second, 90 for the third, and I think thereafter might even be no, they don't say it's perpetual, and a $10,000 fine. It's a pretty extraordinary law.
Yes, because I've always told my management clients, and this has been going on for years, that there is an obligation to verify that people have the right to legally work in the United States before you hire them.
Well, that's what the federal government says. This 2014 law, by the way, has a further hook to it. The further hook to it, and this is the one that I think most employers will be very surprised to know, is California law. Specifically, that an employer is liable, violates this law, if the employer doesn't willingly accept, here, I'll read you the language, an employer may not discharge an employee or in any way discriminate, retaliate, or take any adverse action, which of course is extremely broad, because the employee updates or attempts to update his or her personal information based on, and here's the key, it's a lawful change of name, social security number, or federal employment authorization document. Well, because you can never determine whether something is in fact lawful, that basically means that if you're an employer and somebody, one of your employees, every week comes in with a new social security number, that you have to, it's called, an empty head, just accept it as being valid, which is pretty extraordinary. And if you don't, then you'll lose your right to do business in California.
Including your license, if you, let's say you're a bar owner, for example. Any
license that says that if you violate this law, you lose any license to engage in business in California. Now, looking at this, I mean, there's no court cases on this, and it's got this weaselly word about a lawful change. But since you can't really determine whether or not somebody's, whether it's their green card or whatever, is lawful, and of course with DACA, the Obama era, the deferred action on childhood arrivals executive order, which is still percolating through the courts as to its validity. It's not just green cards; it also includes DACA work permits. So if somebody has a document and they keep changing it. For example, they want to change it, Social Security number, keep rolling, because, well, one might argue because it's not a valid Social Security number, that you as an employer have to accept it. Now, I know many employers that if an employee obviously every, routinely and regularly or with some frequency keeps changing the Social Security number, they're going to say, hey, what's up with that? This law makes it illegal for the employer to question it.
Exactly.
And imposes a really strict penalty.
One of the things that I want to remind our listeners is the phone number is 661-298-5487. Feel free to call in on any labor or employment law or entertainment law related issue, and we need your input. We're here to answer your questions because this has got to be relevant. There's another really, really interesting lawsuit going on up in the city and county of San Francisco in the federal courts involving Lyft and Uber. And it could, if it goes the wrong way from the Lyft and Uber and, quite frankly, a number of drivers' issues, it could really change the transportation landscape, which has been changed dramatically by ride-sharing services like Lyft and Uber and their ability to provide transportation a lot cheaper some of the time than the cab companies. So, Mark, why don't you tell us about that?
Oh, well, actually, that's it's broader than transportation. The what's happening, it's to me it's pretty fascinating, is that let's take the model of Uber or Lyft. Of course, the model of Uber or Lyft is they have individuals with their own cars, meet minimum standards, and they decide if they want how many hours they want to work. It's completely up to them, and they use the on-call service to get customers. That model obviously works very well in transportation, but this on-demand society, it's got all kinds of applications. People using computerized services for everything from rentals, Airbnb, and the like, to Uber, and the potential applications are as numerous as the imagination would permit. Well, the theory in the case is that these individuals that are using Uber are not independent contractors, but are in fact employees of Uber and Lyft. But not employees in the sense, I was on your show about a month ago when we were talking about independent contractors under state law. This is a really different test when it comes to federal labor relations, that is, the right to organize as a member of a union. And the argument here is, that's being made in this case, is that the Uber and Lyft employees, quote employees, put that in quotes because they argue very vehemently they're not employees, at least some do, that they are employees for the purposes of, of voting that they want to join a union. Well, and then you add to that the further layer that we have card check now with union elections. In other words, all they need is the card for an individual that they want the union. There's not a formal election. So what's happening is you have kind of an uncontrolled pool of part-time drivers, and some might really be drivers, some might be people that are, organizers, but in any event, they get to 30% or so, and they want to unionize, and the people who give their cards. The other people are saying, wait a minute, we don't want to pay union dues, we don't want to belong to a union, we're independent contractors. Huge issue.
Yes, exactly.
If they rule that, the card check works, and in fact, you get the requisite percentage, and it gets certified by the National Labor Relations Board, then people who thought they were independent contractors suddenly find that they're members of the Service Employees International Union, obligated to pay dues, whether they want to belong to the union or not.
Not only that, they have the Service Employees International Union negotiating the terms and conditions of their so-called employment,
right,
whether they want it or not.
Of course, what the real driver is that the traditional cab companies, which are charging obviously significantly more than Uber or Lyft, many of them are in fact represented, and will insist that the wages, terms, conditions be the same as the old school traditional cab company, which means, in other words, Uber and Lyft would be gone. It's a huge case. It's a huge case, and it's not clear, how the court will decide it. But I think the more fascinating question on that, really, is that we're in the transition of federal administrations. We had one administration that was with an NLRB that was
extremely liberal.
Pushing the rules to assist in minorities forming a union, with card check rules, etc. And now a new administration, and it's really impossible to say. I mean, the Trump people have been, he's obviously not. He's not hostile to unions. He's got a pretty good relationship with some of the, certainly with the coal miners union, but there are other unions, the Teamsters and the like, have a pretty good relationship with him. So who knows where the administration is going to go as far as the NLRB is. But the politics aside, this court is really a significant issue. This decision is a really significant issue because this whole sharing economy is, it's obviously the trend of the future, and a decision on this one labor issue could essentially shut it down.
Exactly. And what's really interesting, if you look at the difference between cab fares and Uber and Lyft fares, the base fares that Uber and Lyft have are significantly lower than the cab fares. But if you, those of you who use either Uber or Lyft, which I think includes probably at least 50% of you, the dreaded surge pricing, where you can wind up paying, almost double what you'd pay for a cab. The cab rates are based on a set rate. They don't fluctuate. But Uber and the surge rates can go up. I've seen as high as a three times premium, which can get really, really expensive. So I'd remind just before you go in, the phone number again, 661-298-5487. Give us a call. We'll try and tell you how any of these things impact you, because that's what you want to hear about. We can talk a lot philosophically, and it's a lot of fun to do that. But the most important thing I think that most of our listeners are interested in is, how does this impact me? And I think the Lyft and Uber thing is huge, because they have just changed the transportation landscape. There have been surveys done by some people saying it's cheaper to use the ride-sharing service than to own a car in Los Angeles. And having owned a car and owning a car in Los Angeles, I tend to agree with them.
Well, yeah, and also there's a much bigger picture here too, because it's the on-demand or sharing economy. Many argue, this is a growth area of the economy, but more importantly, in the implications for 40 years, mass transit has, and I use mass transit. I like mass transit, but mass transit, is either overutilized, where it's an inadequate service, or underutilized, where it costs taxpayers a fortune. On-demand sharing economy, in many ways, a much more efficient way to address transportation and mass transit. Like you say, it's for many people, particularly with parking expenses, etc., reasonably priced. The on-demand transportation is cheaper than owning a car.
It is. It certainly is, and it has massively changed things. It really, really has. And the places, like owning a car in New York is a pain in the neck. If you live in downtown Los Angeles, owning a car is a pain in the neck, because you got to park it, you've got to insure it, and it's a heck of a lot easier to pick up your cell phone, hit your app, and they'll pick you up in 5 or 10 minutes. It's unbelievable. Who'd have thunk?
The legislature passes their new gas tax, and it's actually a fairly stiff add to the registration fees, which were already, California registration fees are among the highest in the country, I think, if not the highest. They would be allegedly, they're going to be bumping those up pretty substantially. It's getting more and more expensive to have a private automobile. But really, the issue, people always see these labor issues, and they think they're kind of isolated labor law issues. And this one, the Uber and Lyft one, has, macro economy implications, writ large, because it's going to affect not only employment. In fact, the interesting thing about it, I think, the most interesting thing, I have read articles lately that Uber and Lyft have become, sort of favored sources of employment for, single mothers, etc., because it gives them the opportunity to actually go out and make pretty decent money during the time when they're available, midday, early evenings, etc. And you talk to people that do it, and you can make a fairly good side income doing it.
Exactly.
There's very few jobs that give you that opportunity.
Mark, we will touch on this again after our break. You're on the legal line with Dennis Kennelly, and we'll be back after these messages.